Hello, everyone. Welcome to LexTalk, World's talk show presented by Clickaway Creators. Today, we have Mr. A.K. Gupta with us. Mr. Gupta is a well-known expert in the area of trade remedial measures in the country and the founder and the managing director of TPM. With highest number of cases to his name, he's an eminent practitioner and an icon in the field of trade remedies. Mr. Gupta is not just a great practitioner, I would say, but he also believes in giving it back to the society, especially when it comes to the knowledge sharing part of it, which also makes him an honorary lecturer in post qualification course of Institute of Chartered Accountant of India. We actually have a lot of things to discuss about him, and I can't really cover things about him. So, without further ado, let me introduce you to the man himself. Hello, Mr. Gupta. Welcome to the show, and how are you doing, sir, today?
Hello, all well. How are you doing?
I'm doing great, sir. Thank you very much. And thank you very much for joining us for the session. I am really thrilled and excited to discuss things about you. Someone coming with experience such as yours. It's my pleasure to have this discussion with you. So, without further ado, let me hop up to my first question. Uh, if you can tell us about a legal, or rather a complex legal issue that you worked on recently or in your career so far, and describe the complexity around it and how you really approached it.
Okay, so as you know, TPM is about 23-year-olds organization and therefore has been instrumental in redressal of several complex legal issues in this journey. I'll talk about only two of them. The first issue I can talk about is the issue of whether industry is entitled to dual protection. The Indian industry is entitled to trade remedy protection under different laws. These include anti-dumping duties, anti-subsidy duties, safeguard duties, bilateral safeguards under trade agreements, transitional safeguards on imports from China, as was permitted under the accession treaty of China to WTO. A major legal issue that arose in India is whether Indian industry can seek simultaneous imposition of these remedies under these laws. TPM established that the Indian industry is entitled to seek remedies simultaneously under these different laws. Today, industry can take recourse to anti-dumping, anti-subsidy, and safeguard in any sequence. First anti-dumping and then anti-subsidy, or first anti-subsidy and then anti-dumping, or first safeguard and then anti-dumping, or first anti-dumping and then safeguards. TPM analyzed the legal provisions and global jurisprudence on this subject. TPM established that the industry is entitled to simultaneous protection under these laws. After the investigation authority accepted the legal position and granted dual remedies, the same was challenged before appellate authorities. First before the appellate tribunal and thereafter before the Supreme Court. TPM was able to establish legality of simultaneous imposition of measures under these laws, not only before the investigating authorities, but also before the judicial authorities. Today, the law is well settled in India on this account, and industry can seek relief under different laws at the same time. Complexity of the issue is not only with regard to the dual remedies, but also the fact that India applies lesser duty rule, where the duty is lower of dumping and injury or lower of subsidy and injury. Complexities further arose because of the fact that it may be difficult to segregate the injury that is caused by dumping and the injury that is caused by subsidies. In the context of safeguards, the question was to address and segregate the injury suffered on account of surge in import and on one hand, and dumping or subsidies on the other hand. Second issue which I can talk about is how to address the difficulties faced by small and fragmented industry. You talked about where TPM does to the society. It's an area where probably TPM has been talking about ever since we started our journey. One of the issues that concerns Indian industry is filing applications is getting relevant information from various domestic producers. In products involving a very high number of producers, including fragmented industry, it is almost impossible to get data from all the domestic producers, or even those whose collective output constitutes a major proportion in Indian production. For instance, the tire industry in India comprises of more than 450 domestic producers. Meeting the minimum threshold of 25% data would imply more than 50 domestic producers. India follows what we call residuity rule, which further implies that the domestic producers wishing to file petition must provide their 4-year data on both cost and financial accounting. Further information may have to be provided in respect of cost of production of different product types. It is almost impossible to seek protection under unfair dumping or subsidy in such situations. In case of fragmented industry, it will still be bigger challenge. Often the size of individual producer is quite small, and these are owner-driven organizations with little professional experience either on accounting side or on management side or technical or marketing or R&D. Most producers in such fragmented industry do not maintain records in the desired manner. This results in process of even filing application for initiation significantly time consuming and sometimes even difficult to achieve. TPM made detailed representations over a decade to the concerned authorities in India, highlighting this issue. We emphasized on the need for simplifying the procedures, for reducing the burden of information, in order to allow such domestic producers to avail remedies under these laws and WTO agreements. Solution proposed by TPM included allowing applications with limited information, resorting to sampling techniques, and thereafter calling information from sample domestic producers. Our efforts, I must say, have reaped success when in July 21, India introduced a modified procedure in a much simplified manner for filing applications by fragmented industries. The procedure now provides for the following kind of a relaxation to fragmented industry. An application for initiation can be filed by producers constituting 25% or total domestic production. Such producers are not required to furnish complete financial information, as are normally required to be given in the case of large industry at the stage of application itself. Only summary information is sought from such companies. Thereafter, authority resorts to a sampling, and only sampled companies are required to provide this elaborate information. This modified system has already been introduced by India in 2 cases so far. So without getting into many legal complex issues, I think these should be 2 good enough instances of how TPM has been able to help industry in addressing their concerns.
I mean, that's really wise of you, sir, mentioning that. And I understand having more than 2 decades in practice, of course, as a law firm and as an individual, there are a lot of things that are there to discuss. But I'm really happy that you could come up with 2 cases that would really intrigue me, and of course our viewers as well. My next question is about pandemic, which I guess, fingers crossed, I hope we don't see it coming again based on the news that we all are hearing and seeing every now and then around us. In the pandemic, we all saw some courts begin moving towards more remote proceedings and availability, and even the law firms worked on a remote basis. Uh, what do you think? Is this remote culture in legal fraternity, is this sustainable and a possible way to increase access to justice? When you're representing TPM as a law firm, what's your firm's opinion on this?
So when this pandemic issue arose in India, there was almost total standstill for more than 2 weeks, with nothing at all moving in the area of our practice. Thereafter, I must tell you today that we don't feel a need for physical meetings and interface. That's where India could quickly switch over to the new situation. The movement towards remote proceedings and increasing use of digital platform was a really positive step. It has allowed easy and wider participation for everyone, especially across borders. In past, all parties had to physically appear and attend proceedings or hearings. The participation from foreign producers and foreign government was very, very limited. The entire system has changed by virtual hearings. This has made it easier not only for the Indian industry, but also for the foreign producers and foreign governments. While the distance covered by the interested parties previously could range from few hundred kilometers to few thousand kilometers, it has been just reduced to click of laptop. This has resulted in much wider participation, in far more effective hearings. It's highly time saving for everyone. Not just India, even other jurisdictions have also moved towards use of digital environment. This has tremendously benefited the Indian producers facing trade remedy investigations globally. Prior to pandemic, a number of jurisdictions required physical filing of documents. However, post-pandemic, a positive change has been seen. A number of jurisdictions have moved towards online or e-filing. This has not only allowed more time to the stakeholders and also saved significant cost, but also was a welcome step considering its impact on environment. For example, in TPM itself, whereas we would have been consuming more than 100,000 pages a year, we are now consuming hardly 1,000 pages a year. Another welcome change has been with regard to entities who can represent. Earlier, most often, Indian producers had to engage legal representatives in the country undertaking investigation, both for filing and for attending hearings. However, now with e-filing and virtual hearing system, there is no compulsion on the Indian industry to engage foreign law firm. This has led to a significant cost and time saving and resulted in more effective participation by the stakeholders.
That's very true. And we've also seen it helped in terms of lawyers for appearing in different jurisdictions at a single time, as you've mentioned. So that's very good to hear your take on this. When it comes to experience, years of experience, Mr. Gupta, there's no doubt that I cannot ask you a controversial question. Not that much of controversial question, but it's about justice gap. How would you rate the current legal system's drive towards encouraging access to justice? And first question is actually there are part of these questions. Is there a gap? And if there is there a tangible way or tangible moment in which we can close the justice gap?
It's not only an interesting but also a contentious question. The current legal system has taken significant steps to encourage access to justice. We have seen in the area where we work. Recently, the Director General of Trade Remedies introduced simplified procedures for participation by various stakeholders. Relaxations have been offered to fragmented industries. However, we believe even with these steps, the requirement for seeking remedies continues to be cumbersome and quite limited. In some cases, we have experienced that domestic producers do not have the resources to generate the data or the documents required by the investigating authority. There is significant scrutiny of the data, much more than any other jurisdiction. As a result, it becomes a costly and time-consuming process for any producer to seek recourse to these remedies. Despite the DGTR setting up a help desk for this purpose, the present requirements are so significant and complex that a domestic producer cannot think of succeeding without the help of legal consultants. Therefore, while there has been some progress in this simplification of processes, a lot is required to be done to ensure easy access of the legal recourse to industry at large and without the help of legal experts. In fact, I firmly believe that the system should be so aligned that there should be no need for a legal professional to work on, particularly in the areas of trade remedies where the accounting expertise is of bigger relevance and the industry already holds that expertise. But unfortunately, we are in a situation today where domestic industry cannot think of succeeding with the trade remedy measure without the help of a legal consultant.
Yeah, I mean, that's right. So what you're saying is there is an intent in terms of, so there is a gap and there is intent from everywhere to close that gap. I mean, if I have to summarize it this way.
So I'll put it this way, there is certainly an intent to simplify, but at the same time, the complexities are increasing, the stakes involved are increasing. And since the stake involved from foreign producer side are also increasing, it is really becoming difficult for the industry to take recourse to this without the help of legal experts. In fact, India has been quite on a receiving end on this account, where because of small lapses happening, the industry had to bear very unbearable cost. So I personally feel that there is a need for far more to be done on this regard. But I would put this way that Indian system is far more lenient on this account as compared to any other global jurisdiction.
Mhm. And coming years, the complexity will increase, or year by year, the complexity seems likely to be increasing.
Yes, it's going to significantly increase year on year basis with increasing participation from parties with conflicting interest, particularly in India, given in a comparative term, low legal cost involved. It's easier to really engage legal consultants. And that is one reason why India finds so many legal litigations happening as compared to any other global jurisdiction.
What's the solution to this? If you can, I mean, I know it's a very long discussion. We can do another series on this, but if you can summarize a solution on this, how can this all be sorted out? Not all of it, of course, but what's the steps that we can take?
Government is taking steps. In fact, very recently, they have directed CTIL to provide services to Indian industry. And CTIL being part of Ministry of Commerce, they are supposed to provide services free of cost. So today, industry actually has access to free of cost services. Despite that, I think it was announced more than 6 months back. Not a single case of success so far. One of the reasons being that the area of our expertise is a highly expert area, very technical area, because of which the domain knowledge itself is extremely limited. And since the domain knowledge is limited, naturally the costs are high. But yes, on the other side, I must say that the profile of parties available has significantly increased. As opposed to the past, when I was in government, there used to be hardly 2 or 3 law firms who could really say that they practice anti-dumping. But today, I think the number is certainly crossed single digit. I can say it may be in 2 digits where firms can say that they hold some knowledge about this. But still, would you call a 2 digit number a great number in terms of availability of legal expertise? I would probably say it is too small a number, given the kind of information system which is available, kind of exposures which are available. So maybe gradually as the system matures and more legal expertise becomes available, the cost will come down. But recourse to legal system, unfortunately, I feel will only increase and will not come down.
Okay, okay. I don't think we should go deeper into this, but I guess our viewers really got an idea of what's happening and what is to be done, and maybe what's coming in coming years. In the era of in the era of legal technology, Mr. Gupta, which was really catalyzed by the pandemic, ironically, what are the most commonly used tools for you to ease the process? I mean, I'm just not just talking about case to case, I'm talking about as a law firm as well. Because being a law firm with more than 20 years of experience and a lot of history in it, when technology comes in, it brings a lot of disruption with it. I mean, positive and negative. So, how you really handle it, and what are the commonly used tools for you as a law firm?
So I can talk about 2 kinds of technological availabilities today. One is in terms of IT and second is in terms of legal. So I'm not getting into IT technological tools which have become available. But for these tools, probably it would have been impossible to proceed further. We all are well aware the kind of video conferencing systems where we have jumped in, the email systems and WhatsApp messaging systems. I'm not getting into IT part of it. But in terms of the legal technology, if I talk about, the most important technological tool for any legal professional today is access to information that is being generated by global community. We are quite fortunate to be in contact with international chain of lawyers wherein knowledge and disclosure is disseminated frequently and research is made accessible through advancements in technology. Increased communication, accessibility to information, and ability to present views and submissions throughout the world are most important technological tools for the legal community. Today, we are with the global systems and procedures and practices to our advantage, which has become available because of the legal technological advancements that have taken place. A lot of jurisdictions have gone online, and that information system has become completely available. Probably the only bottleneck in this area remains the language barrier. Some of the jurisdictions, such as China or Korea, today still work on their local language and not in English medium. So, barring that handicap, I would put it this way, that we are really fortunate in getting access to what happened in US yesterday, and that's really helping us a lot in taking care of the investigations where we represent the industry.
It's very well put, sir. Um, Thank you very much. So far, this has been a great session. I mean, we have talked about a lot of things from yours and from the firm's standpoint. My last question to you would be about time management, and a lot of young professionals who want to make big in the industry. We have had so many discussions with so many people, and we've always found out that the time is very important when it comes to lawyers. And as they say, time is money in any profession, and in legal, it's most of all. My question is, how do you ensure to make the best of your time as a lawyer?
Okay, so I think I must tell you two things here. First of all, we have never allowed availability of time to be a reason for any investigation to suffer, irrespective of nature of industry, irrespective of the kind of fee. Number two, we have never considered time as a relevant factor even for pricing our services. However, time, of course, is very relevant and important for any professional, therefore for us as well. The key for ensuring best use of time is prioritizing and appropriate deployment of resources. We have a team of more than 40 professionals at our office. In India, we have the largest team dedicated to trade remedies. This allows us to handle each assignment effectively by ensuring that sufficient resources are allotted to any investigation. We spend significant amount of time in deployment of human resources through orientation sessions and handholdings. This investment in developing resources ensures the team is equipped to handle assignments more and more independently, which while delivering quality of the work. However, we believe that no assignment should suffer only because of deployment of time. We do not allocate time on an assignment considering the remuneration. We allocate time considering the need of the assignment.
Mhm. So if I may also sort of ask you another follow-up question on this, what will be your suggestion to the young professionals who are trying to make big in the industry? I mean, how can they make the best of their time?
Again, I would put it this way, that the best thing is to identify the problem and only try and address the problem, not getting into any other areas around it. I have seen a significant time is spent in really getting into the concerns which are really not bothering the other side of the table. So if you can point out what exactly is the problem and just focus on that, that is one area, one way where you can save on time. Second is use of right resources and right skills. Once you identified the problem, you should only be looking at right resources, and probably you can save on time.
So again, I mean, I guess this is relevant for a lot of us. I mean, even for me, rather than talking about, I mean, majorly talking about why the problem occurred. It's about what is the problem and how it can be solved. It's about what and how more than why. That's how I can put it. Mr. Gupta, this has been a great session. I mean, I thoroughly enjoyed it. For our viewers, where can they find you and TPM if they want to get a hold of you and the firm?
In terms of access or in terms of visibility?
I'm talking about, I believe that TPM has a website. and TPM is also available on LinkedIn. So how can they reach out to you guys for their concerns?
So of course, our contact details are available on our website. By now, my experience has been that new industry has approached us by contacting other stakeholders. In fact, most often when I ask people in the beginning of my career that who referred my name, to much of my surprise, the answer used to be my opposing parties. The reference to me had been coming most often from those who had seen me on the opposing side. And most often I have seen those who faced me on the other side are my next clients. So probably best reference comes from the work, and people will really look at where you are. And in today's world, it's not difficult to locate a person. If you just do AK Gupta or you do a TPM consultant, you can not only reach out to me, but also where I'm located, where I'm sitting. The world is so easy these days, thanks to the IT tools.
That's a very savage. I mean, and I guess savage is the right word, not a very formal word, but the right word to be used in this session. So, as you guys have heard, all the viewers, if you want to get a hold of the firm, you can type TPM Consultants over Google and click and then just enter, and you will find the firm, and you can get a hold of all the contact details that you want if you want to reach the firm. There you go. Thank you very much, sir. This has been a great session. Again, I guess I'm mentioning this for the third time. And of course, we look forward to having a chat with you again in future on some other training topics in the international and, of course, national legal industry. So thank you very much for joining us,
Thank
sir.
you very much. Pleasure talking to you. Thank you.
Thank you, sir. And for our viewers, if you like this chat with Mr. E.K. Gupta, I want you to like this video, to share this video, and click on that red button to subscribe to Click Up Your Creators YouTube channel to appreciate what we do. And we have more coming in from legal industry leaders like Mr. Gupta himself. This was Sagar for LexTalk World signing off.